Welcome to Estate Planning, Securing the Future for Your Loved Ones. I'm Kim Raisler. In my day job, I'm an attorney, but I'm actually here wearing two other hats today. First, I'm a center parent, and second, I'm a member of the newly formed Center for Discovery's Board Development and Endowment Committee. As committee members started having conversations with other center parents and families, they found that families had many questions about planning to secure their loved one's long-term future and quality of life. This includes questions about estate planning for financial security, decision-making into the future, transition to adulthood, and related questions. To help us navigate those questions, I'm very pleased to be joined by Adrienne Arkontaky. Hi, Adrienne.
Hello.
Adrienne is also wearing two hats today. Adrienne is also a center parent, and she is an attorney and vice president at the Cuddy Law Firm. Adrienne's the perfect person to be guiding us through this conversation today. She practices in the area of special needs planning and special education advocacy and litigation. She's devoted her entire career to addressing the legal needs of families with loved ones with disabilities. And she helps families plan for the future by developing special needs estate plans, including special needs trusts, discussing the potential need for guardianship and advance directives, and other legal matters associated with securing a loved one's future. We'll leave a little time at the end for questions, so please add any of your questions in the chat box on your Zoom platform. So, Adrienne, thanks so much for joining us. As a parent of a loved one at the center, I wonder if you could just begin by giving us a general overview of planning for the future for your child.
Sure. First, I want to say thank you so much. Thank you to the center for organizing this outreach. It's such an important topic. I've been preaching about it forever. As people who know me, and some of you are on who know me, I want to start by saying this is absolutely not a sales pitch for the Cuddy Law Firm. There are phenomenal attorneys out there that do this work, that can guide you through this. You certainly should explore those options, and we have some resources at the end that we'll talk about and give you. You can always email me if you're somewhere upstate, downstate, and I can always give you referrals also. Oh, here's a list of resources. So I think I want to start by saying that this is so important because planning for the future of a loved one with disabilities is quite different than just general estate planning. So we don't want you to lose sleep. We want everybody to go to sleep with peace of mind that our loved ones are taken care of. And the first thing that I want everybody to do is recognize that this is not a one-size-fits-all plan. You have to look at your unique situation. You have to say, what do I want for my loved one long-term? And the question that is in everybody's mind is, what happens when I'm no longer around? My husband and I are no longer around to take care of our children or adult children with disabilities. So what you really want to do, the first thing you want to do, and this is an exercise, and by the way, it can be very painful, is you really want to take stock. You know, we have clients come in who say, oh, I just want a will done, or maybe I don't need a will because I don't have much of anything. And then we give them this inventory of assets, this list, and we ask them, just write down the things that you have. Well, I have a house. Oh, I have a co-op. Oh, by the way, I have these stocks. I have bonds that were given to my son or daughter years and years ago. I forgot about those, you know. They're in the safety deposit box, which we'll talk about. you want to really sit down and take stock and take an inventory of what you have. All right. And then you really want to, figure out how this plan will play out, okay, over your lifetime and when you're no longer around. All right. And you want to work with someone on the estate planning side that really does this every day. Okay. Kim and I are talking about what our practices look like, and, and you practice in entertainment law, right?
That's right. Yeah.
So I said to myself, that sounds so interesting, but if somebody came to me with an entertainment law question, I would say, I have this friend and her name is Kim, go see her. The same thing with special needs planning. So you may not, you're not going to go to the person that does your real estate closing. You're going to go to someone that really does this every single day. And you ask them, how many trusts have you done? Have there ever been challenges to them? What do you know about public benefits? So you get the answers to these questions, and you decide what you want your plan to look like, and you start early. And there are many, many things. It's not only about estate planning. It's about guardianship. It's about transition planning. It's about securing access to government benefits, and making sure that your adult child, has all the opportunities and a great quality of life, because the public benefits certainly are not going to provide for everything. All right. This crass way of describing it is they'll provide the hamburger and maybe not the steak. So that's how you want to start. You want to take stock. You want to do an inventory of assets. You also want to prepare what's called a letter of intent. You can Google a letter of intent, get it off the internet. If anyone wants one, you can email me. There's no charge for it, and you don't need a lawyer to do it. It's not legally binding, but it's certainly that exercise to figure out what you want to do. So that's where I would start.
And what about timing? When's the best time to start?
It's never too early. You certainly should have an estate plan early on. Even before people have children, they should have an estate plan. Everybody needs a will. Everybody needs advanced directives. And the way I always describe it is, how they say if you're in an airplane and something happens, you should always put your mask on first before you take care of that's the analogy I use. You have to take care of yourself first. So it's never too early. Certainly when you get a diagnosis or you think there's an issue, start as soon as possible. I've been doing this a long time, and I've had clients come to me and say, the person said that you don't need this yet. You don't need a special needs trust yet. You never know what life's going to bring. And so you want to make sure as early as possible that you start this plan. If things change, how someone looks at 3 might be very, very different than 18, but the plan should be fluid. And these are the tips I want people to take. If you go to somebody that just says, this is the will I do, and this is the plan, and it can't be changed, find somebody else, okay?
Right. And it can be changed, right?
That's the important thing, Kim. You're right, is that it can be changed. And certainly, this is exactly what I'm so sorry. I told everybody, do not disturb me between this time and my daughter's calling. Certainly you want to make sure that whoever's doing this has the ability to change things. And yes, it can be changed. So that's an important thing to keep in mind.
Great. All right. So let's go on to what are the steps one can take to make sure the financial security and the transition into adulthood.
Sure. So the first thing you're going to do, you want to fill out this inventory of assets. So in my firm, when someone comes in, we send them this questionnaire, And it's a double-edged sword because some people see the questionnaire and they get so scared about having to put everything on paper that they, it takes months and months to fill it out. But do that first, okay? As soon as possible, do this inventory of assets, put pen to paper, do the letter of intent, okay? Then one of the questions on the questionnaire is, do you have advanced directives? Do you yourself have a power of attorney, a healthcare proxy, a living will, a disposition of remains, a HIPAA release? So you want to make sure that you have all those things, because again, you need to plan for yourself. So you want to get those done. So if you go to an attorney and they say, oh, I'll do the will, but I'm not going to do the advanced directives, I think you should question that, all right? Because here, we do wills and trusts all the time, but we absolutely do advanced directives because you need to have these documents in place so that if you yourself have a problem or you can't make decisions, that somebody can make those decisions for you. So you start there. Then you definitely want a will. Everybody needs a will, okay? As small an estate, as large an estate as there is, you certainly want a will, because there's always a fallback. If you're not going to, have a trust in place, you'll always have that will as a fallback. For our kids, there are many tools to achieve what we want for our kids long-term or adult children. But a special needs trust is very important. And we'll talk about that, the types of trusts. But you really want to consider whether you need a trust in the will, which is called a testamentary trust, so that everything passes through the estate. A trust is established via the will, but it doesn't come alive until you pass away or the second partner or spouse passes away. You want to address guardianship, not only for our loved ones with disabilities, but our minor children. Because remember, again, what I want people to take away from this is not the technicalities. That's what we're here for. These good attorneys are here for. And some nonprofits obviously can help with some of these issues, but we have minor children that we need to designate a guardian for. And the thing is, you want to make that decision. I know people get scared and they say, oh, the state will come in and they will take our kids and they will do this. It's not that, but you don't want the courts to have to decide. If you want to go to sleep at night and say you have a plan where you made the decisions, because you're the best one to do that. You're the best one to say, if something happens to my husband and I, my partner and I, and my child is not 18, this is the first person I want in line to make decisions for them. So you want to make sure you address guardianship for minor children. A special needs trust, you want to make sure that you address that. The other thing I'm going to plug in, and I don't want to forget this because we do quite a bit of special education advocacy, transition planning is crucial. It is addressed through estate planning, through guardianship, but it's also the responsibility of school districts to help families make that transition from school to adulthood. And school districts they have the responsibility to let parents know what should be done post 18. So in some districts, they'll have a transition coordinator. Most districts, I have to say, don't get, A's in this area, but we're helping, we're helping to educate them through these presentations. And what you really have to do is make sure that through these school districts that they understand that there's OPWDD eligibility, there's SSI, supplemental security income, there's Medicaid, there's Medicare, there's SSDI. And at least if they could let parents know about this and prepare a child for post-high school, post-secondary education, vocational programs, residential placements, they're doing their job. But we as parents, we really have to just make sure that we're holding everybody accountable.
Great, great. So maybe we can just be clear about and the difference between a will and a testamentary trust and a special needs trust. And
Okay,
just for the different purposes of the two.
All right, so a special needs trust is either testamentary or it's inter vivos. And if that doesn't confuse people enough, there's also a first party trust and there's a pool trust. So to make this sort of a better flow, the most basic type of special needs trust, third party, meaning that there's no Medicaid payback, okay? This is a trust where the funds passed from either the grantor or the testator to the trust itself is a third-party trust. That means that it never went to the beneficiary. The money never went to my daughter Jordan. It went from my estate or my bank account right to the third-party supplemental needs trust. Now that supplemental needs trust, that third-party trust can be in the will. It's basic, it's less expensive, but the problem is it doesn't come alive until we pass away. Okay, so for a family that wants to have a trust set up where other people can contribute, and this is the type of trust we have, it's funded with minimal funds right now, but that's an inter vivos trust, and it's
during your lifetime.
Yeah, we can fund it. People can give gifts to it. We run into families who say that aunts and uncles have said, I want to give, I want to give a gift to Jordan. I want to give a gift to, this beneficiary, but I don't want to disrupt any government benefits. So the inter vivos trust is a nice mechanism because we have a friends and family letter, and we're not having the client send it out saying like, give donations to the, Jordan Arkontaky Trust. But we're saying if you want to give a gift, instead of giving it to her directly, you can give it to her trust, all right? Won't disrupt the benefits. They can give it during her lifetime. But also there's no Medicaid payback, all right? There's nothing that's going to go to the state. And the way I explain it is that it never went to Jordan, all right? It went from me, it went from her aunt directly to the trust. So that's a third-party trust. It can be testamentary in the will. It can be inter vivos set up. It's living right now. People can contribute to it right now. There's lots of caveats. I think it goes beyond this this conversation, but one of the things that's really important in general is that if a child's under 18, a parent really should not be the trustee and should not give directly to the trust. We could do a whole seminar on that, but it is really basically because they have an obligation to support, and they can provide for their child directly. They don't need to put it in the trust and then, distribute from there. And also there are other ways to do it, but so you have testamentary, third-party trust, inter vivos, third-party trust. The second best type of special needs trust, and you'll hear these words interchangeably, special needs, supplemental needs trust, the other type is a first party. And that trust is used if someone gets a med malpractice settlement. Some of our kids, the injuries have been a result of med malpractice or personal injury, or a gift was given inadvertently directly to the beneficiary, to Jordan, all right? My aunt wanted to do something, didn't listen to us, and made the beneficiary of her CD, Jordan Arkontaky, all right? There's no way to undo it. Once the gift is given, we have to do something with it. What what happens, and I want parents to understand this, and Kim and I were talking about this, there's always something to do. I don't want people to, be frantic and say, oh my gosh, she's going to lose her benefits. Something's going to happen. She's going to go off Medicaid. But the second option by statute is this first party trust. It looks in all ways like a third party trust. The only thing is that at the end of the beneficiary's lifetime, Medicaid does present a bill in almost all cases. And we'll say, listen, we let you keep the benefits during her lifetime. We didn't disrupt them, but we're going to give you a bill. All right. And usually what happens is we go through the bill, we figure out if it's right, if it's correct, and then the trustee writes a check to Medicaid. The one thing I will mention, again, these are just like nice little tips that you take from here, is that and this is when you need an attorney, okay? This is not something that parents should be doing on their own, negotiating Medicaid liens or paybacks, but you have to look at whether any of the services were provided that Medicaid is billing for under the special education laws, because there's a carve out. So those services do not generally have to be paid back, the costs, right? But again, an attorney can help you with that. A good attorney will know that they really should scrutinize that bill. So that's a first party trust, and it's used when there's an issue. Somebody found stocks, somebody found bonds that were really in this loved one's name. You can fix it, right? And then there's a pool trust, okay? And a pool trust is managed by a nonprofit organization, and typically it's used for smaller sums. It's definitely not as expensive as setting up a first or third party trust, and the nonprofit will manage the money. So the family comes to me and says, listen, there's this $10,000 IRA, there's a CD, we need to do something with it. It's not, in many cases, not worth it to do a trust for that. But remember, there are always pros and cons with all these trusts. So the pool trust is great because it's less expensive, but at the end of the individual's lifetime, that money will stay with the nonprofit, okay? And some people are great, happy with that because it'll go to one of the programs. I don't want to forget to say, what's the purpose of these supplemental needs trusts? Remember, it's to supplement and not supplant, supplement and not replace the government benefits. So folks have to be careful what they spend the money on, all right? With a first party trust, you're definitely going to have some reporting to the Department of Social Services, and in many times the court. We do a lot of trust administration, so we help families navigate because it can be daunting. Do you really know whether this expenditure is appropriate? And it should really be, in general, not food and shelter and not medical. But if you work with someone, they'll tell you if Medicaid's going to pay for a very simple wheelchair and you want something over and above, then that's something that would be legitimate. So those are the types of trusts.
Well, clearly everybody can tell how important it is to have someone who has a wealth of experience in the special needs area. Clearly, we can see how important that is. So maybe we can get into a little bit about guardianship and advanced directives and all of that, and transition into adulthood.
Okay, so, and that's another really important thing. People ask me, when do you start? I'm telling you, start as soon as possible with estate planning, right? Get that out of the way. You look at it every 2 or 3 years. Now, your loved one turns 16, 17, and you're saying to yourself, what do I have to do post 18? Or maybe you're not even thinking of it. Maybe you're saying to yourself, with Jordan's needs are so intense that who would ever question that, I can't make decisions? Well, at 18 years old, every person becomes an emancipated adult with their own rights, okay, regardless of the severity of the disability. So you need to start thinking at about 16, what will life look like after 18? How much support will this individual need? Okay. And it's a daunting question. It's emotional, all right, because kind of, this is it, all right. The courts really want to use the least restrictive environment, just like we talk about special education law. They want to look to what are the least restraints, all right? So if we do many guardianships, but I will tell you that this is probably one task that parents in general can do it on their own, unless there are some issues like assets in the child's name, or there's a custody, battle, or the mom or dad can't be found, or there's just something that's not kind of plain vanilla, all right? But you have to start thinking of, what do you do at 18? And that includes a few things, all right? It includes the possibility of guardianship, the possibility of going to court and taking the position that your loved ones cannot make their own decisions, all right? In New York, we have two types of guardianships right now, to Article 17A under the mental hygiene law, or I'm sorry, Article 81 under mental hygiene law, or Article 17A in the surrogates court. The difference is that Article 81 is a very tailored guardianship. So you go to court and you say, Johnny doesn't need my help with vocational decisions, but he certainly needs my help in financial decisions. It's a very tailored guardianship. It's expensive, and this is one you should use an attorney with. All right.
When you say expensive, maybe can you give us a sense of?
Yeah, full disclosure, I don't do many 81s here because they're used a lot of times in elder law. I'll say upwards of $10,000, $12,000, because it is there's a hearing.
That's not a standard.
No, but it's expensive. It's expensive, and many of our children don't need Article 81s. I mean, as I said, this is a general comment. The more streamlined guardianship is really 17A through the surrogate court, and it usually is done in the surrogate court where you live or where the individual lives. So, I always say I'm an open book. Jordan's guardianship was done in Sullivan County. They are phenomenal in Sullivan County. It's a streamlined guardianship. There are, full disclosure, there are some challenges right now to 17A. There will be some changes to it because it's what we call a plenary guardianship. It doesn't tailor anything. There's sort of a quasi hearing on it, but in my view, and people have different views, 17A was really meant to be very easy for families to navigate. It was really meant for a child like Jordan, who has these significant disabilities. It was very clear that she needed someone lifelong to make decisions. It is, again, in many cases, even when families call here to have us do it, well, I always have the paralegals say, you can do this on your own. If you don't get overwhelmed, you need 2 doctors to attest to the need for the guardianship and the developmental disability or the intellectual disability. There's a petition, there's some consents and waivers. But another tip, if you take anything away from here, is the best friend you can make is the clerk at the surrogates court, wherever you live or in Sullivan. They are super helpful, super helpful. Typically, it's the parents, or maybe not, but the parents or a caregiver You appoint standby guardians. So in my mind, it's always the what if. So my husband and I are guardians. My daughter, my oldest daughter was standby, named standby. And then at the time, my youngest daughter was not old enough to be named. So we named a nurse who had taken care of Jordan. But now things change. Like you say, Kim, you look at, every few years, you say to yourself, is everything the same? What needs to be changed? So we recently added Jenna, added my younger one, who's going to be 23. So the point is that you look at these things, you ask for advice, talk to other parents. How did they lay this out? But the important thing about it is that you try to get it done before or at 18, so that there's no gap, because in many cases with our kids, we've been going to the same doctors for years, right? And they may not ask, okay? But you don't want to be the person in that ER when they're asking for your guardianship papers and you say never did it. But on the other hand, I don't want families to worry if they haven't done it. People, they get so worried about it. We've done guardianships for 80-year-old people. And we had to do it for specific reasons, but you can always do it, right? So you have guardianship. You have guardianship in surrogate, you have it in Supreme Court. Then the other option is advanced directives. So you have a high-functioning kid with autism, someone who with CP, but is really, really bright and understands and can appreciate these documents that say, if I can't make this decision, or I need help filling out the forms for Social Security, my mom can help me, or my dad. And by the way, every kid turning 18 should have advanced directives, all right? And I'm saying that with the caveat, if you have the advanced directives, you can't have both, the guardianship and advanced directives. But my other daughters, Justine, who went off to college at 18, and Jenna, who went off to college at 18, have advanced directives. They have a healthcare proxy, power of attorney, HIPAA release. And again, they don't take away somebody's ability to make decisions. They just appoint someone else if they can't or if they need help. So those are advanced directives. For the kids, I usually do power of attorney, HIPAA release, healthcare proxy. Give them a little card. You can get it, I think New York State can issue it, fill it out, get the witnesses, and it's done. And then the third thing is really supported decision-making, which there's a big push right now for supported decision-making. It basically says you're not going for guardianship, and maybe you're doing advanced directives, but you have sort of a team of people that can help this individual make decisions. The problem right now is that it's not supported by statute, but there's a bill in there. And for some people, it's absolutely a great thing. And my dear friend, Judge Glenn, would tell me, she would kill me if I didn't talk about it. So, and she has been a big supporter of this. So those are your three options.
Okay, great. All right, and then let's talk a little bit. We're talking about adults and what happens when you're gone, how you can set your adult child up through your will to make sure that they are financially secure and that they can have a good quality of life.
Yeah. And that's what it is. It's really, making a plan, and it's different for everybody, of how somebody will have the best quality of life that they can. Because remember, the government benefits, and this is in the case law and the statute says, the government benefits provide a floor and not a ceiling, all right? So what we want to do is make sure that they have closer to the ceiling, right? And you can do it in different ways. You can do it through life insurance, all right? You can name the trust as a beneficiary. You can do it through payable on death accounts. You can do it through property. You can do it through IRAs, 401ks, bank accounts. And you always want to make sure that the designations are correct, that they go to the trust. And that's really the way you do it, so that there's a long-term plan. People ask me how much is enough, right? How much? I don't know. This is a typical lawyer answer. It'll be like, it depends, you know?
Yeah.
So you look, you know, I will tell you what I look at. I look at what I think government benefits will provide for 5 years down the road and say, maybe put 5 times that, you know, aside. I don't really have an answer. But the other thing, and maybe I'm jumping the gun a little bit, but you know, the other thing is really planned giving.
That was my next question.
Yeah. Yeah.
So we'll ask about that. So.
Yeah, it's important because, you know, planned giving is really planning a gift for the future. Okay. To an organization, typically nonprofit, to a charity, to wherever you want, that is, you know, I said this, you know, Kim, I said this when we talked, it can be in gratitude for what was done, or to provide for the future, and you know that it's going to in some way provide for your loved one. And you can, that's an easy thing to do, because what you're actually doing, you may not have the wealth available right now, okay, to give. But you can say in your will, at the end of my lifetime, I'm going to give a direct gift to wherever. I'm going to name this nonprofit or organization as the beneficiary of this one life insurance policy. It's easy, you know, because you don't have the wealth available. You can name
a percentage too, right? It doesn't have to be all.
Yes. Yeah. And it can be a planned gift over time. It can be doled out over time. There's so many creative ways to do it. And you really need to talk to someone, again, that does this all the time, to sort of come up with a plan of how will you do this? Will it be an ongoing gift? Will it be a gift of, you know, one account? Is it, it really depends on your unique circumstances. The other thing I think is very easy to do is add the organization at sort of the tail end of the bequest. Okay, so for instance, and again, you know, everyone knows I'm an open book here, but in you know, a trust, you can say at the end of this person's lifetime, whatever's left in the trust goes to this organization. And you can name several, you know, so that maybe you want to thank somebody for what they've done in the past, but you want to provide also for the future. And it's a nice, easy thing to do. It can be done via trust. It can be done via life insurance. It can be done in the will. And it really allows you to feel like, you know, in some way this person will be taken care of because you're helping the organization.
Wow. Well, thank you. All of your insights were really, really helpful. I'm sure that we have a number of questions. Was that one question that we had? So one question that you were talking about all the different kinds of trusts. And one question is, can you give us a sense of what kinds of costs are there in some of these trusts?
Yeah, you know,
you've got the will too. You know, estate planning can be expensive. So what's the range here?
So I always say, you know, when people call, they'll always ask me, can you, you know, do you have a quote of what it's going to cost? And the reason I don't, in my practice, give quotes, because I'm terribly wrong all the time. Because until somebody tells me what the estate looks like, it's hard for me to determine what the cost will be to set it up. The one thing I will say is no one should not do this, if this makes sense, because of the cost, because a lot of attorneys, they'll work it out. I mean, if you have a simple estate, you shouldn't be faced with costs of 10, 15, 20,000. If there are tax implications, I think somebody And again, you know, I'm not a tax lawyer, but if you have a huge estate, I will say, you know, you'll go to an attorney who has a tax background, who maybe can do some tax planning in this. So is that going to be expensive? Yes. I can tell you in my practice, we do estate planning on a flat fee basis, because the other thing I don't want families to be faced with is, I don't want to make revisions because, oh my gosh, Adrienne's charging, you know, whatever per hour. There's certain things we do hourly. This is not one of them. Because the other thing you should be able to do is see all these documents. You should be able to make revisions. You should be able to read through them and understand what you're signing. All right. So the cost, you know, it really depends for us on the size of the estate and what we have to deal with. Do you have properties out of state? Do you have, you know, accounts that need to be retitled? And that's, you know what, Kim, and I said to you, this is a lot for even 45 minutes. One of the most crucial things when you work with with an attorney is that after you complete the plan, if you have a special needs trust, that all the beneficiary designations be reviewed. You have to review them, and you have to make sure that they're titled correctly, because there was a case years ago where the attorney just, you know, did the documents, everybody signed, and never looked at all the assets to make sure that the beneficiary designations were the trust, and the money went directly to the loved one, and the plan went up in smoke. So another thing to take away from this is make sure you look at the beneficiary designations. But the cost, you know, I'm not skating around it. I'm saying many attorneys, it's worth the consultation fee. And then in my practice, I give a flat fee.
Got it. Thank you. Thank you. We did have a question about the tax benefits of giving to a nonprofit versus.
Yeah, I knew, you know, I will say in general that there can be some tax benefits. It depends on the plan. So you should, you know, certainly talk to someone. The special needs trust in general, they're not really many tax benefits, but the plan given can definitely provide some benefits. So you can, you know, it's a win-win. Anybody that knows me knows this is not, you know, a promotion for anybody. It is a win-win. You'll feel good, get some benefits, and know you go to sleep at night with peace of mind.
Okay, so do we have any other questions in our queue? Okay, here's the question. What's the difference between a revocable trust and an irrevocable trust?
Yeah. All right, that's a great question. So a revocable trust, there's more opportunity to amend it. You can transfer the assets out. You certainly will lose some benefits. I'm sorry, tax benefits. The special needs trusts, a lot of times are revocable during the lifetime, during our lifetime as the grantor or the settler. But then you want them to be irrevocable, all right? The ultimate is that they become irrevocable, because that's where the benefit of keeping the government benefits comes from, is the fact that the beneficiary gives over any discretion. So the trust becomes irrevocable. There's some people that say, oh, it cannot be changed. Nothing about it can be changed if it's irrevocable. That's not really true. We can amend it. We put clauses in it to say if there's a change in the law. So irrevocable really means once the money's there, all right, once the house is there, once the stocks are there, they can't be taken out generally without some kind of impact, all right? Impact to the government benefits, other impact. The revocable trust, which is not generally used long-term for a special needs trust, the money can be come in, come out. The terms can be changed more. But you really, really want to make sure that at the end of the day, the special needs trust ultimately is irrevocable. And you want to make sure if you're looking at a third-party trust, that there's no Medicaid payback. That's the other thing that is really important, because if you have a third-party trust and I have seen this where they have drafted it with a Medicaid payback, it's malpractice almost. It is, because you're saying, okay, come in and get this money that wasn't yours to begin with.
Okay, great. We had previously showed the slide on resources.
Mm-hmm.
I mean, the question is, how do I find the right attorney and other resources? We had a list of resources. If we want to put that back on the screen, maybe.
Yeah.
Okay.
So,
if someone wants to take a screenshot or a photo of that, they might want to refer to some of those websites.
and let me just, the Special Needs Alliance, you can Google it. They give a list of attorneys in every state that have been really vetted through this organization, and there's only a couple. The Academy of Special Needs Planners, probably there are more attorneys on that list because it's not an invitation only, but they certainly have looked at them, and they look like they have the qualifications. NALA, even though it says National Academy of Elder Law Attorneys, it are really elder law and special needs planning attorneys. They usually have a nice list. If anybody is out of the area and they want, a referral, I'm happy to do that. Again, there's many attorneys out there that I would trust with that. The last resource was the DIY program, because if you go to New York, the newyorkcourts.gov, they have like this checklist of what you need to do to petition for guardianship. And again, people try it. If it becomes overwhelming, just make sure when you're, interviewing an attorney that they have done this many, many times. Google their names, see if they've done presentations, see if they have really, an expertise in this area, because this is something you want to get right. You don't want to really wind up having to go back to court and, revise something.
Okay, great. And do we also have the poster? Okay. So thanks so much for everyone for joining us. And Adrienne, thank you so much for all of that great information. If anyone wants more information about this seminar, or this webinar, whatever you want to call it, please contact Strategic Outreach at tcfd.org. You can see the poster on your screen. Take a screenshot if you want. They will help you follow through with any questions and help you access resources. Also, if you want more information on planned giving, you can reach out to Anna Kornelakis at the address you can see right there on your screen.